as Democratic Campaign Council of Ventura County instead of firefighters for the better Ventura County government. 2, agenda number 10, we have a letter submitted by the respondent, Mr. Bob Roper, dated February 22nd, 2013. Agenda item number 11 and number 12, memo from Mr. Craig Steele requesting a continuance regarding matters P 2012-05 and P 2012-06. Finally, agenda item number 14, staff received the signed stipulation, decision, and order for matter P 2012-11. Thank you.
I'm sorry, I may have misheard you. With respect to 11 and 12, those matters involve, according to the agenda items, 2012-05 and 2012-09. Did I hear you say 6?
No, sir.
Okay, my mistake. And those are to be continued to what date?
It will be up to the commission to establish the next date. As of right now, staff's calendar is scheduled for March 29th due to the agenda items which we can discuss later, and the next meeting date would be April 19th.
All right. All right, item 4 then, approval of the meeting summary for January 18th. I've read the summary and it comports with my recollection of what happened, to the extent that my memory is good.
I'll take your word for it. And move the approval.
Second, any objection? Hearing none, we'll approve item 4 then. Okay. Item 5, commission members and staff comments. Mr. Johnson, do you have, well, first of all, go ahead.
Yeah, do we have anything for the public first, or is that at the end?
That's at the end in our agenda. We have a speaker card for item number 10, which we'll hear at the time we take up 10.
I had a number of comments after kind of wading through this as to, I say some are comments and some are questions. I don't know if now would be the appropriate time. Maybe I'll wait. I think that on item 10 there was a letter from the candidate that kind of went along with some of the same observations I had. So rather than take the time up now,
Okay.
I'll come back to it.
I'm looking. I had some comments which I made initially to staff, to Ms. Lee, that perhaps I ought to share at least in part with the other commissioners concerning some of the work being performed. I have some frustrations, and let me just mention a couple of them. One is that it's difficult for me as a commissioner to take up a matter, a disposition, let's say, which I haven't seen until the day of the hearing. The commission's function in approving or disapproving a stipulated decision involves some evaluation and weighing of the potential of harm to the complainant, the degree of culpability of the respondent, the cost to the community of the investigation and proceedings, the fairness of the disposition in light of others made. And I thank Mr. Steele for, at least in some instances, giving us the meat of the proposed stipulation prior to obtaining the final settlement documents. I understand that it's oftentimes difficult to get those documents from counsel or the respondent, him or herself, and I appreciate having at least an idea of what we'll be evaluating ahead of time. I do think that even where the agreement hasn't been finalized by signature or otherwise, some advance notice of the parameters or outlines of what is being discussed would enable the commissioners then to make that evaluation or go through the process of determining the degree of harm, the degree of fault, the fairness in light of other decisions, and so forth. So I would encourage, or I would like to encourage, that the commission get in advance, as far as possible, those proposed stipulations. We've continued an awful lot of matters, and we're going to continue several today because of the lack of finality of them and so forth. But at some point, the decision becomes somewhat moot because of the lapse of time. So those are a couple of my frustrations. See if I...
Yeah. At the risk of you and I becoming known as Statler and Waldorf, the two old men in the balcony, I would like to comment. Some of the thoughts I had were along the same lines. My note to myself after going through kind of volumes and then to get the continuance and not actually even know in a couple of cases whether or not the subject of the complaint had done anything to comply with the complaint, because I noticed in some cases there were comments as to cooperation and response time and significance of, my note says, I may be wrong, but I come to the commission meetings to base my judgment on both the recommendation of the investigator and any challenges raised by the subject of the complaint. And because this is not precise by any means, trying to find some sort of fairness both to the candidates as well as to the community that's paying for all this. One note I would mention up front is, at the very least, I think that we should reproduce things printed 2 sides. That would at least cut the volume of paper in half, even if we're not able to sort out some of the other procedural things that I think are pretty disturbing. So, shall we proceed?
All right.
I'll be Waldorf.
Okay, then moving on to the informational agenda, I think 6 and 7 can be handled together. 6 and 7 involve a receive and file request for prior commission activities, reports, and the amended policies, both of which the commission has acted upon and now the Board of Supervisors has acted upon. So I'd move that we receive and file items 6 and 7.
I'll second that, and here's one place where I'd like to make a comment. Inasmuch as we've taken the action and given direction to staff, and staff has carried out that direction, it would seem that possibly a 1-page confirmation memo or something would be adequate. My assumption is that once we take action and that the staff is competent enough to carry it through, that for us to be sending communications back and forth and filing when it is not advancing the purpose of the commission is probably one place where we could create an efficiency.
I agree, and there's no action to be taken really by the commission at that point in time.
Plus, we're very familiar with the content since we took it. Yeah.
Hopefully.
Yeah.
All right, number 8 then is a request to receive and file correspondence for the complainants and respondents with respect to P10001, P10003, and notices of no violation for case numbers P2012-3 and P2012-4. That merely confirms actions previously taken again by the commission. So I'd move that we receive and file that item.
Chair Z, I'd like to make a comment.
Yes.
Just for the public notification. The items taken by the commission and the signed stipulation, including the declarations of no violations, have been posted on the commission website. Over the past year, staff has worked really hard to update the website to ensure that public can gain access to the electoral cycles. So I just want to make sure that the public is aware of the website is available online. Thank you.
Very good. All right, moving into the regular agenda then. I believe that at this point in time we're going to receive an oral report from Mr. Steele concerning 2012-1, 6, and 7.
Morning, Mr. Chairman, members of the Commission. First, let me say that with regard to your your comments during the informational portion of the agenda, I take those comments to heart and understand the Commission's concerns, and will endeavor to work within those and meet those concerns wherever possible. I would just note for your information that it is a little bit of a unique situation, given that the deadlines that are imposed on me to report back to the Commission and to provide materials in a time that allows them to get out to you in advance, those deadlines don't apply to anybody else in the process. And so I'm at the mercy of documents coming back to me in a timely fashion as well. So we do try to get things wrapped up as expeditiously as possible. With regard to the item that came to you yesterday, in hindsight, maybe it would have been better to put that on a future agenda. However, I have a deadline imposed on me to take an action, make a recommendation within 60 days. So I don't have the option to put it on a future agenda. So it's sort of a catch-22 situation in some of those cases, but I do take your comments to heart, and we'll keep trying to move these things along as quickly as possible.
Thank you.
In that regard, with regard
Mr.
to
Chairman,
the two...
I'd like to-
Yes.
Sure.
Just in response, my remarks did not in any way refer so much to the investigation. It was, as you point out, procedurally, we've got to figure out the timing on these things, including in the clerk's office, because I spent a whole lot of time trying to figure out 3 complaints, one of which we're hearing today and 2 last time, concerning this whole issue of the declaration of, taking the spending limits and the difference between a primary and a final election, and then the clerk's office saying, and we can't send you the letter till we certify the results of the primary, which is like a month out. That stuff, now that we've been through this, we should get that sorted out. If we can't figure that out, the rest of this is going to really be a challenge for us.
And I would agree in separating out the chair's concerns from your concerns. I understood those, and would note also that one of the cases you're going to hear today is essentially just a late filing. It's not anything other than late filings, which in most jurisdictions that I've worked in wouldn't even come to this process. And so that might be something else to work out that could get, speed things along and take the Commission out of what is essentially sort of a ministerial late filing kind of issue. That's another one of those list of things to look at with the benefit of history now behind us. But with regard to the 2 items in item 9, or the 2 sets of items in item 9, there's the case number 2012-01, the Donald Becker complaint, and the 2 complaints against Citizens for a Better Ventura County. I'll separate out the 2 items, although they are related in that I am dealing with the same treasurer for both respondents. I had originally set a meeting with that treasurer a few weeks ago. That meeting was delayed at her request until last week. Met with her at length in her office last week to work these matters out. With regard to the Citizens for a Better Ventura County matters, I anticipate we've come to an agreement on those matters, and I anticipate at your next meeting you will have the stipulation before you and in plenty of time to look at and consider. That's not a case that's in dispute anymore. The other matter with the Donald Becker complaint, that matter became factually more complicated after our meeting, and without potentially prejudicing a hearing that might have to come before you, an evidentiary hearing, I will tell you that both the treasurer and I have been in touch with the Fair Political Practices Commission, because resolution of that matter really sort of needs their cooperation and their advice as to how to resolve a case here without violating state law. And so that's taken a little bit of work to get through. to make sure that we're not creating a violation of the Political Reform Act by resolving a case here. But we are working on it. I have been in contact with the FPPC. I hope to have this matter resolved and before you at your next meeting. But it is somewhat complicated as a legal matter to work out, and that's why it's taken a little bit of time.
So are we talking then at this point about setting a date to continue those three matters too?
I would request that those matters be scheduled at your next commission meeting. I understand there's a question as to whether it'll be in March or April, but March would be fine with me, I think. I think both of those will be worked out by the end of that date that's been reserved in March. If you're not going to meet in March, April is certainly fine as well.
My understanding is this would be the only thing we would hear in March if it were continued to March. And the suggestion is that perhaps rather than having a meeting for that limited purpose, that they go over to April.
It's fine with me. It's not exactly timely now anyway, so if an extra month makes it a little more efficient, I agree.
Shall we then continue these three matters to April 19th?
That's acceptable to me, sir. Yes.
Okay.
Second.
Hearing no opposition, those three matters in agenda item 9 are continued to April 19th.
Thanks.
Thank you, Mr. Steele. Number 10, we have a speaker's card on number 10. Mr. Roper? I'm sorry, in introducing the item, number 10 is on before us on a recommendation to dismiss. My recollection is that item 10 is similar to another matter involving the other candidate. Both candidates essentially did the same thing with respect to accepting contributions after the primary, prior to filing a notice of voluntary expenditure limitation. Is that your understanding?
Yes.
Okay. Go right ahead.
Okay. Bob Roper, candidate during the 2012 general election for the supervisor of District 1. I support the recommended action, and I just gave you a copy of some comments I wanted to speak before your commission. I wanted to ask you to, as a commission, to evaluate the overall campaign ethics rules. I strongly support the ethical actions by all candidates, but we must ensure that our rules do not discourage candidates from coming forward and serving in the democratic process. The electoral process should be simple. A candidate should be able to enter a race to represent a platform, expect a level playing field. They should also be held accountable to a set of ethical standards so the public is not misled. As a first-time candidate during this process, I learned many valuable lessons during the 2012 year election. The existing rules are unclear and sometimes in conflict with the state's FPPC rules and reporting practices. The real proof of this dysfunctional ethics rules is that even the architect of the rules was accused of the violations. Another consideration to revise the campaign ethics rules is the financial impact of the investigation and the review process before us. Why does Ventura County have a set of rules more complex than the state's? Why is the reporting process different than the state's? Do these rules create a system that is confusing? It appears to me that after I read all the allegations filed in 2012, I couldn't find that there was any malice intended, yet look at the cost and the time expended in the process. The goal before us is to ensure an open atmosphere for future candidates to become engaged in the democratic process and not to create obstacles that inhibit involvement. The strength of our democratic process is that voters have a choice on the ballot. Let's ensure that we protect and strengthen our electoral process. Please review the rules in the future and ensure that they are simple and fair to both the challengers and the incumbents. Thank you.
Thank you, Mr. Roper. Just by way of comment on your comments, those comments are probably more appropriately directed to the Board of Supervisors than this commission. This commission certainly has the authority to make rules and to interpret those rules. But the statute itself, the ordinance itself, is a product of the Board of Supervisors. And to the extent that your unhappiness with the ordinance needs to be rectified, it would be the Board of Supervisors to do that. Mr. Johnson?
Many of my comments then probably would be best directed to the Board of Supervisors, because I share much of the frustration of the speaker, in the sense that the reason I think it's worth commenting on here is that I don't know that anybody actually pulls all the pieces together and sees, I wouldn't say conflict with other laws, but certainly there's some inconsistencies that create conflict, not necessarily legal conflict, but just practical conflicts. And I mentioned the one where the clerk's office doesn't even certify the election of a primary until almost 30 days later, and then that's the only notice given to candidates. It would seem to me that one of the things we could, as a commission, recommend to the board that they take a look at that section, and the only reason it was confusing is because of the word each. Or possibly the form that's put out. It seems to me that if we were to look at the form, and the form were to, if I was a candidate and I declared myself to be willing to stay within the spending limitations, it would seem like that should uphold through the final election unless I revoke my pledge, rather than to have to renew my pledge, which I may or may not even know I have to do until 30 days after I violated it, which is what happened in our process for 3 of these complaints, 2 last time, and it appears this one is in the same general category. So I agree with your comment that maybe all of us should share our thoughts with the Board of Supervisors. I think everybody's trying to do the right thing, but as to the question of effectiveness and cost benefit, I think that we have a ways to go to perfecting what it is we're trying to do.
Well, of course, the candidates do have the option of making that voluntary decision for both the primary and the general election at the same time. They, however, in the cases that have come before us, have only made that election with respect to the primary, waiting until the completion of the primary before making the decision with respect to the final. So the form isn't defective in terms of allowing them that option.
Well, that may be the case, because I haven't looked to fill out the form, but it just seems strange to me. Here's 2 things that seem very strange to me reading the record. One of the key authors and revisers of the ordinance had the same problem as a brand new candidate. They didn't apparently recognize it. And one of the other things that was disturbing, as far as how we're all cooperating as opposed to intentionally or unintentionally nullifying this ordinance, is the fact that an inquiry was made, I presume it was by telephone or something, because I never saw the documentation, was made like in July by the co-author of the ordinance, who was a candidate, asking how it was to apply, received a response from the clerk's office saying, this is our take after consulting county counsel. I assume it was county counsel, lawyer or counsel. And the comment was, is anything before such and such date falls under this section, vice versa. Okay, now that's in July, and that candidate then took steps, apparently, trying to correct it, even though the violation was still filed as an apparent violation, although a technicality, by the clerk's office. In October, if I'm not mistaken, the other candidate, Mr. Roper in this case, inquired and said he understood there was a potential problem. If we all are cooperating and understood what that meant, I'm wondering why we didn't immediately send notice to the other candidates when it became evident that there was a, quote, technical violation, to be sure that everybody was on the same page. And as a result of not doing that, we've spent a huge amount of time in every one of these offices to no particular benefit. So, again, I'm Waldorf. Yeah, I realize I'm grumpy-eyed.
You're not grumpy. All right, then.
I could address one issue there if you want.
Certainly.
Part of the issue with those voluntary expenditure limit statements is the clerk's office doesn't see a report of contributions received until August, and doesn't know until that form is reviewed, whether any of those contributions were received before the second general election period voluntary form was filled out. That there's no apparent violation in July. You don't know anything until you see the next form showing contributions received, and then you'd have to compare that date with the date on the voluntary acceptance. My understanding is the clerk's office has changed the form to make it more explicit that you can pick both periods or one or the other. And a candidate may want to pick the expenditure limit for the primary and may not want to be bound for the general for financial reasons. So there are a lot of issues with those things, and also there's many elections happening at the same time. And some of this, just on the clerk's behalf, happens because they don't so much fall through the cracks as they're just not triggered by anything. They don't come up, they don't rise to the surface.
Well, it sounds like, one, you've addressed the issue, which is to make it clearer on the form, and two, my comments are not directed at that the clerk has some responsibility for this, just simply pointing out that if everybody is trying to make the ordinance work, whether it be the CEO's office, our commission, legal counsel, when something comes up that seemed to be somewhat extraordinary, particularly in light of who the players were, I suppose that the legal counsel that reviewed this understood that it was not being asked by a person who had something to do with the writing of the ordinance, that it might have been something that we should be sensitive to and start being sure that there are only, 11 candidates that are even covered, or 11 election offices that are covered by this. Not to put the burden on the clerk's office, but it seems like we could maybe collectively figure out how to be better communicators with those 11 office elections, because they're not even all up at the same time. It maybe gets it down to like 7. Anyway, it's just a frustration, and I guess the comments made by the candidate, a former candidate, that, you know, the idea of encouraging people to participate, it seems like a lot of this has become red tape. I know it's maybe we're in the R&D development of what we're doing, but after a few years, I guess that's probably not going to be a satisfactory explanation to the public. So.
With those comments in mind, I would like to move the approval of item number 10 and comment that it appears to me that there was certainly no intention to violate the ordinance, that both candidates acted in a responsible fashion upon being apprised of the premature acceptance of various contributions, and went to some considerable expense and trouble to rectify the situation, and that dismissal is appropriate.
Second.
Any objection? Hearing none. Number 11. Oh, I'm sorry. Yeah, 11 and 12, we were set to continue.
I did have one question on these two. Did he, on either of these, was there any effort, the last thing that said something about that, or at least in the letters, said that we had not heard anything back. Have we received the necessary filings with whatever I guess it's what, 1, you're supposed to electronically file it, and 2, you're supposed to explain what the kind of the message or the
Yes,
the media was?
we've received all of the required filings from this entity since the last.
That was a question I had too. The 1275 reports have been filed in both cases.
Yes.
I
Okay.
was wondering why we didn't at least receive that much with this, because there's no, okay, well, we'll take it up at the next meeting, but yeah.
Apropos of that comment, though, these matters tend to be discovered and proactively acted upon by the clerk upon the filing of the state form 640. There's no indication of when that state form was due for any of the periods mentioned, and therefore no way of measuring what the amount of delay was. And certainly there's no mention of the filing of the 1275, so we don't have any way of saying the obligation to report within 24 hours arose on X date, and either the election intervened and made it moot, or the form was filed, so we have some measure of the duration of the failure to act.
Between the 460 and the late filing, that's the duration period you're talking about. You'd like to have that information?
Yeah, and even perhaps some indication about whether the 460 was timely.
Yeah, I always note in the final report whether the initial filing was timely or not, so I will do that in these cases when they come back before you.
So you're requesting then, Mr. Steele, that we continue 11 and 12
To your next meeting. 12, I guess, till the April meeting that
till
we've
the
continued
April
together.
19th meeting? All right, any objection to that? Those matters are continued to April 19th then.
Thank you.
Thank you. Number 13.
Mr. Chairman, item number 13 concerns complaint number P2012-08. The respondent is the Democratic Campaign Council of Ventura County.
Yeah, I'd like to emphasize again that the identification of the firefighters for a better government was a typographical error in the first paragraph of that letter, board letter, commission letter. It should have been the Democratic Council of Ventura County.
Of Ventura County. The Democratic Council of Ventura County is a general purpose committee that is organized to support candidates both in county elections and outside of in elections outside of the county, or the jurisdiction covers areas outside the county. The complaint alleged that the respondents violated Section 1275A of the Ventura County Code, which is a section that requires that a county form disclosing independent expenditures in excess of $1,000 be filed within 24 hours of making the expenditure. On May 30th of 2012, the committee distributed a mailer. I believe you have a copy of the mailer in the packet. It supported a number of candidates. I think sort of commonly we would understand it as a quote-unquote slate mailer, recommending that a number of candidates for a number of different offices be voted for. Technically, under state law, it's not a slate mailer, but that definition is not relevant here. There was only one candidate on the piece of mail that was a participant in a county election covered by the ordinance. That was Supervisor Bennett, and there was a recommendation that the recipients vote for Supervisor Bennett in that supervisorial election. The respondents reported a expenditure in excess of $1,000. They properly and timely reported that expenditure on the state form. They did not file Forms 1275, which is the county late independent expenditure form, within 24 hours as required by the ordinance, nor did they file a copy of the mail piece itself, which was also required by the ordinance. They were notified of the violation by the Elections Division after the election, and they then filed Form 1275 and a copy of the mailer on November 23rd, which was after the election. The expenditure on behalf of Supervisor Bennett was approximately $1,600 or $1,800.
$1,800.
I'm sorry, $1,800. Getting my math wrong. $1,800 for that share of the cost of the mailer that was distributed within the supervisorial district. I'll again stress that there was no effort to cover up the expenditure. It was properly reported on the state form. It was timely reported on the state form. The treasurer of the respondent informed me and admitted in our first phone call that he simply didn't know about the special form that needed to be filed in a county election. So there was no effort to conceal the expenditure. In this case, it was simply a matter of being unaware of the county's form that needed to be filed. However, in this kind of situation, normally in late filing cases, we have imposed, if we've imposed a fine on a first offense, it's been relatively minor. In this case, however, the independent expenditure reporting is a bit more significant that it be reported timely, in my view, because it triggers certain additional notifications that go to candidates, and it makes people aware that these independent expenditure groups are operating in a county election. So for that reason, even though this is a late filing case and it is a first violation, and the respondent has been cooperative, I recommended a more significant fine than we have typically imposed in this case. In fact, I think it's probably the biggest fine that I've imposed in a first violation case in this county, which is the $1,000. And the respondent has agreed to that $1,000 fine for one count. It was a one count violation, and that stipulation is before you. We have the signed stipulation as well as the cashier's check received from the respondent, and we're recommending that you approve that stipulation.
Thank you.
The trigger in this case was because it was over $1,000, is that?
Yes.
But it was not a lot over $1,000. I guess when I read the case, the concern I had was that the fine in this case is symbolic more than anything else. It's clearly not a deterrent because of the amount. It's not high enough to scare anybody, but it is just to remind people that it was in fact a violation. There were consequences. It's not enough money to pay for the actual cost for your services and all the rest of us, so it's not like we're being reimbursed. And it seemed like the case, the way it was described, it was totally innocent and totally above board, in the sense that sometimes we get those mailers at home and they come up with, sort of the Monty Python, the old, what is it, the Judea Front, or the People's Front of Judea. Nobody can remember what the committee's name is, but I get stuff in the mail and it sounds like, oh, these are people that are endorsed by people that I know, and then later you discover, no, they just paid a fee and somebody sold them a spot on it. This one doesn't seem to be that kind of a thing. They complied with all the state laws and everything. I guess my inclination would be, if it's just symbolic, then we not assess a fine greater than what we've assessed in the past, but no less than what we've assessed in the past, and then start maybe ramping this up based upon education to people. I don't know if that, I know we jumped on you before, or at least on staff, about let's get tougher, and now as soon as you do, now Waldorf here is hitting back again, but it...
I think, if I recall, I think the normal target of Waldorf's heckling was Fozzie. So playing the role of Fozzie Bear today.
Okay, Fozzie.
I will just comment that, in my mind, I look at each one of these cases based on sort of 20 years of experience in this type of enforcement system in other jurisdictions. Mm-hmm. In my mind, this is a more serious late filing violation than the item that's going to come before you next, or other types of sort of ministerial things, because this is a group that's not really on the ballot. There's no candidate's name on this mailer. There's a group's name on the mailer, and the filing requirement triggers other things that happen in the process. And so I believe that the educational value of this fine needs to be a little more hefty in order to make sure that people are aware of this filing requirement and that they understand that there's going to be a consequence with 4 figures at least in it if they intentionally ignore the filing requirement. That didn't happen in this case. This is, I think, as you've surmised, this was not an intentional violation. But in terms of the effect on the process, there's no difference between an intentional violation and a negligent violation in this case. And so I believe that the education value of this fine needs to be a little heftier than it does in a normal late filing situation. And I think this number will get the attention of treasurers who participate in the independent expenditure process. And because this late filing had adverse consequences on other things that happen in the process, that's why I've hit this respondent a little harder than we've hit others who have merely committed late filing penalties.
Bravo, Fozzie. Very nicely done. Okay.
I note you made a Monty Python reference and a Sesame Street reference in the same meeting.
I came to the meeting today fully prepared to support your recommendation, and I think it's appropriate. I would note, however, that the matter was triggered by the filing of the 496, which is required for or expenditures made within 16 days of the election, and that it must be made within 24 hours, and was. So it was timely in that sense. And I appreciate the fact that although the information was immediately made available, and there's no guarantee that the other affected parties would know of it by virtue of the state filing, we have 1275 for a reason, and people have a right to rely upon 1275 in determining what expenditures have been made when. So I can support it. I do note that $1,000 is about 56% of the $1,800 expenditure. And I note that in the continued matters that we're going to be facing, especially item number 12, for example, that the expenditures total about $18,400. And if these are technical violations, as the one before us with the Democratic Committee is a technical violation, I just hope that we have some consistency and at least a rationale for comparing the recommended dispositions.
Well, you will, and part of the reason this one is important to get approved is because it sets the bar for other cases. But I won't promise you that it's a percentage matchup. That's one way of evaluating it. There are other ways to evaluate the fine as well. But this does, in my mind, set the bar for similar violations going forward.
Good. All right, I'd move the recommended action.
Okay, just before we do that, I can't find here when exactly the complaint was filed, but my recollection was it seemed like that the violation occurred during the primary. Is that correct?
The violation occurred in May.
Complaint was filed in October.
The complaint was filed in October. I think it was October
29th.
October 29th.
Yeah, and I would just, I guess again, that's some of the parts that frustrate me a bit. Maybe there's no way to deal with it, but a problem that occurred in a primary that was over and didn't reoccur during the final election and doesn't get resolved until after the final election is completed. You know, I'm wondering what the actual impact is, but okay, that's.
Is there a second?
I don't know if it's appropriate to. I said, I don't know if it's appropriate to follow up on your remarks as to the relationship between the significance of the type of violation in 11 and 12 versus this one. Are they similar kinds of complaints that timeliness as?
They're the exact same violation,
Right,
just with different amounts.
With the dollar amount being substantially greater individually and collectively of both complaints. I think it's more like $35,000 if you add them together. But I guess more
11, 12, yeah.
Yeah, more significant to me, and I guess maybe I'm playing the king's conscience here, but I was looking for what the attitude was on the part of the what do you call it, the respondent? Is that the proper term for the person who's being complained about?
Yes.
And it nothing in our folder showed that even it responded. You now say they have responded, but it seems like on the issues of fines, where there is judgment to be involved, a certain amount of sort of responsiveness, timeliness, attitude should also have, you know.
Well, it certainly would. I've never had a professional treasurer, and there's a professional treasurer involved here and also in 11 and 12 and the earlier items you continued. I've never had a professional treasurer in Ventura County that hasn't been cooperative. All the professional treasurers I've dealt with have been cooperative, and they have been, you know, people have fairly good repute in
But
reputation in the industry.
timeliness of, say, if somebody has a telephone bank going or doing a push poll at the last minute to affect the election and spending lots of money on it, part of the reason I presume that people would like to know who's doing it and in a timely way so that they can do whatever they can to counteract or neutralize.
Right. But in this election, frankly, the professional treasurers who are not in Ventura County, they're elsewhere. They didn't know that Form 1275 existed.
Right, but my question would be, are they the ones that then respond and file the forms
Yes.
with the message and what was done?
Yes.
And so we just don't know whether they were particularly timely and cooperative, but you're saying that you haven't had a problem with them?
I have not, and I will tell you, I always put an item in the stipulation if they were cooperative as one of the mitigating factors.
Yeah,
I
okay.
would tell you if they weren't cooperative, and we probably wouldn't have a stipulation if those treasurers weren't cooperative.
Okay, so your motion is to,
Approve the recommended action.
okay, okay, the 55% fine.
56, yeah, but who's,
I second
yeah.
the motion.
Hearing no objection, that's approved.
And I will just, I want to just be clear with regard to the 56% comment. That's not the way I've been looking at these. I have a consistency argument that I'll bring forward, but I've not been looking at them as a percentage of the expenditure.
It
So I
wasn't
don't
my intent
want that to be the
to
expense.
bind you in any way that way. It's just one of those factors that we have to look
I
at.
appreciate that, yes.
All right, moving on then, number 14.
Yes, Mr. Chairman, this is a recommendation that you approve a stipulation in case number P 2012-11. This is the most recently filed complaint, the last complaint that I'm aware of. It came to me right around Christmas, as I recall. It simply is a late filing case. However, it's a late electronic filing. There's a requirement in Section 1278 of the ordinance, which requires that committees file electronic copies of their statements once they have raised over $10,000. On October 5th of 2012, the respondents filed a paper form 460, which listed contributions of $22,699. That filing triggered the local, not state law, but local law electronic filing requirement in Section 1278. The respondents did not file electronically as required by the ordinance. The respondent treasurer indicated to me that she was not aware of the electronic filing requirement until being notified by the clerk's office on or about November 30th. On November 30th, upon receipt of the complaint, the respondent then tried to file a PDF version of the report for electronic uploading. There were some technical back and forth until the respondent received the proper technical requirements to get the forms uploaded. 410 was filed electronically on December 5th, and 460 was filed electronically on December 6th. The respondent treasurer, again, doesn't contest the late filing. She merely notes that she filed on time. In the hard copy version, it indicates that in her view, and she is a treasurer who works in a lot of jurisdictions, there's not enough technical assistance available from the county to help committees meet these requirements and learn about these requirements that are different from state law and different from other counties, and that's the defense excuse, if you will, that the respondent committee raised. In other late filing cases, we have either imposed a very small $100 fine or issued a warning letter. In this case, it was my judgment that the numbers involved and the timing of it was significant enough that it justified the smaller first offense fine rather than the warning letter, and that's why I'm recommending, and the respondent has agreed to, the imposition of a $100 late filing fine. Under state law, just as a point of information for the commission, a clerk is permitted, although not required, to collect a $10 per day late filing penalty, and that's the only penalty for late filing that is provided for under the Political Reform Act. Again, that's not a requirement, it's an option, and this particular late filing is an additional county requirement, so it doesn't really apply. I'm merely giving you that information for comparison purposes. And so with that, I would recommend approval of this stipulation.
Thank you. Any questions of Mr. Steele on this item, 14?
Well, not a question, but just a comment. I guess initially my reaction is that it looked like it was warning and education was sufficient, but if there's some legal or symbolic reason for, like consideration in a contract of $1, if that has some value, and I guess probably for no other reason, that the check is already written, is that correct?
Yes, and the stipulation
Okay,
is
so we
signed.
aren't saving anything, probably increasing costs by me wanting to make it a warning. That would make it probably more expensive for them to go back and...
And I understand the warning. I would just, maybe I'm cutting a fine line, but there is a little bit of a significance to this over those where I have recommended to you only a warning letter, and that's why I went with the monetary fine and not just the warning letter as I have in other cases.
Okay, and I guess in the form of an apology from me, when I initially came on the commission and we first started talking about this stuff a year or two ago, my reaction was, this is costing tens of thousands of dollars and we're charging a $100 fine. Why aren't we out there, it's not bounty hunters, but at least covering our costs? No, I'm talking the opposite way. But the more I look at these cases, and with the comments that Mr. Roper made regarding some of the confusion and the complications of what we're doing, it just seems like wherever we have, it sort of the tie goes to the people who are cooperative, who have had the least impact on the outcome of an election and those kinds of things. But I guess we're beyond that now. So now we've set the floor and it will gradually ramp up. So you may disregard
philosophically,
this.
I mean, if you ever see a money laundering case, for example, or an intentional cover-up kind of a case, and I've handled those in other jurisdictions, we're not going to be talking about a less than $1,000 fine for an $1,800 expenditure. We're going to be talking about a $5,400 fine for an $1,800 expenditure. You have to take into account the nature of the violation and separate, I think, people who don't understand how the ordinance works in a relatively young ordinance versus people who are trying to hide their activity. Unfortunately, we haven't seen any of those intentional violations, at least that have come to me over the course of 3 cycles now. And I think we have to recognize that, and that's how kind of a distinction that I try to draw in the enforcement process.
And that certainly is a reasonable way to approach it. I guess my somewhat narrow and practical mind is that there's a difference between a table stakes poker game and a penny ante poker game, and the cost of doing business. Okay, so lay the fines on me. That's probably the cheapest thing I do in a campaign that runs in the hundreds of thousands of dollars. It's cheaper to pay $100 or even $1,000 and be done with it. And I just hope that as this goes along, that we're able to figure out when it's in this low end where everybody gets their hand slapped and it's more kind of like public censure or reputation that is the penalty, and then we get into the real issues of cash. But I've said my piece for the morning. Thank you.
One of the things on my checklist of things to consider in determining whether or not a particular disposition is appropriate is what the harm to the complainant was, or whether there is any perceived harm. And I presume that in determining how you wish to recommend disposition, you check with the complainant or with the the candidate, the complaint in this case was the clerk, it was generated by the clerk's office. It involved a candidate in the process. Is input from the candidate or the person potentially harmed solicited?
It is not actively solicited. In this case, well, in this set of cases, I had a very long conversation with, 2 long conversations with Supervisor Bennett, and heard his view on sort of the whole set of complaints that impacted him. In my view, in the political realm, actively seeking the input of a complainant as to, or the other party in a campaign to find out sort of how things impacted them is not particularly productive, because the complainant is always going to tell you that his political rival, whatever his political rival did, was the worst thing ever. And I've been involved in politics long enough to know how personal these things get, and certainly in these set of cases, that individual rivalry and the tenor of the race have come across to me, even though I don't live in Ventura County and don't have anything to do with the elections. I think it's more important to sort of sit back, look at the statistics, look at the evidence, and say, did this have an impact on the election, or could it have had an impact on the election, sort of dispassionately, and not say, did it have an impact, or could it have had an impact on the campaign? Because there's a difference between what an impact on a campaign and an impact on an election. And that's what I've done in these cases. And although, as I say, I did have a very long set of telephone conversations with Supervisor Bennett, and I'm fully aware of what his view on these issues is.
All right. Do I have a motion? Second. Hearing no objection, item number 14 is approved as
Thank you.
submitted. Thank you. Let's see. 15 public comment. We don't have any additional cards. So, any further business to come before the commission? Ms.
Yes.
Lee?
If it's the pleasure with the commission, I'd just like to recap cases that will be heard on April 19th. I understand that the commission will be canceling the March 29th meeting.
That was, I believe, the suggestion of staff?
April 19th is the next commission meeting. At that date, we will be presenting case number P 2012-01, Donald Becker, P 2012-05, P 2012-09, Firefighters for a Better Government, P 2012-06, P 2012-07, Citizens for a Better Ventura County. I also understood from the investigating attorney this morning that we'll have resolutions on all those 5 cases. With respect to case number P 2012-10, Bennett versus Lund, at the request of the chair, staff has sent a letter to all of the respondent and complainants, including counsel, informing that the staff of the commission has entered into a contract with outside counsel, Fred Wucher, who will be preparing a legal briefing at the commission's request. We are on schedule to receive, or I am on schedule to receive, the legal brief from Mr. Wucher next Friday, February 28th. Furthermore, the respondent, Mr. Lund, has been informed if there's any opposition, his legal opinion is also due to the staff no later than March 22nd. But he has until March 14th to provide his legal briefing. I plan to submit the agenda, the materials, and all of the materials to the commission no later than April 1st, 2013. However, upon receiving any legal briefings regarding matter P 2012-10, staff will forward it on to the commission for your advance review.
Okay. Any questions from council? You know, I must say, I'm less concerned with compliance with the briefing schedules that was previously set out. I'm concerned that we have the briefs in time to have the commission review them prior to the hearing on the 19th, and that both sides have an opportunity to respond to each other's briefing. So if some change needs to be made in that schedule to accommodate that, please let me know.
Okay. My understanding is there's going to be outside counsel for both opinions. The county clerk has not yet entered into a contract, but that's being currently negotiated. And I think at least having that 2-week period after Mr. Wutcher's opinion coming is going to be necessary. But
Okay.
when that 2 weeks begins and ends is up to you.
I just didn't want to hamstring counsel or outside counsel with a briefing schedule that wasn't workable or didn't afford them the opportunity to respond in a timely fashion.
I do understand that counsel for Mr. Lund, if hired, is available on April 19th, so that wasn't a problem.
Thank you. Any further business to come before the commission? Then we are adjourned.